I'm starting a live video with Facebook Live. I just don't think this is working. I'm not sure if I'm going to have to call Facebook or what. And then lastly, I'll be talking about comparative negligence, for those of you that can hear me on the radio show. And as always, I give priority to your calls, people that call into the show, or when Facebook Live is working, people that may type into the show. So interrupt me if I'm talking about jury selection, if I'm talking about arbitration clauses, if I'm talking about comparative negligence, but you have something on your mind that is not one of those three things, please call me, please type in your question, because again, my priority is you, so that I can help you out with whatever may be going on, and hopefully give you some decent direction with what direction you should go. Let me see. So I wanted to bring up something because of a phone call I got was it last week or maybe 2 weeks ago? I got Don called me and said, what can I do about Facebook because they've unilaterally canceled my account, and the reason they've given me for canceling my account seems kind of bogus. And if you were listening, we heard us have that conversation. But I actually looked into that. I did some research into that. And Don, if you're listening, feel free to call back into the show. But Don, apparently you're not the only one. Apparently Facebook has been culling their accounts. And according to the customers whose accounts have been canceled, it's all very similar to yours, where it seems like bogus reasons that Amazon is giving for canceling accounts. One of them, there's my mother chiming into Facebook, so apparently Facebook Live is working now. Good morning, my beautiful mom up in Tennessee. Nice to see you. Sorry for the hiccups this morning, but Facebook Live was not working as I started my show, so I had to kind of reboot, but I'm glad to see that it's working now. So welcome to all of you that are watching on Facebook Live. This is Vastola on the Law, and I am Jeff Vastola, your host. You can type a question of your own, and I'll be happy to talk to you that way. But one of the comments that I read in that article about customers' accounts being canceled is that somebody's talking about a class action lawsuit. So Don, keep your eyes open, keep your ears open for potentially a class action lawsuit for folks who have had accounts canceled by this very large retailer. I know I gave away the name, but so be it. Personally, I'm still having a hard time understanding what the class action might be, unless, of course, what people are saying is true, and that is that the reasons that are being given for cancellation are bogus. I would imagine when you sign up for something like an account online, there's terms of use, and you have to check the box to say, yes, I've read all 10,000 pages of terms of use because I want to buy this can opener, and you're stuck with it. Well, the retailers are stuck with their terms of use as well. So if they've violated terms of use, then who knows? This could blow up into a huge class action lawsuit, and maybe ultimately one day you'll own Jeff Bezos' yachts. I heard that he bought a very large yacht to pull behind his other very large yacht. Good for him. Topics for today, jury selection. If you weren't listening last week, I actually had my first jury trial since COVID 3 weeks ago. I had a jury trial up in Vero Beach, and glad to say we did very well for our client. But what was interesting is picking a jury in our new world of COVID with masks and separation and everything else. Again, I'm happy to say that it really wasn't that unusual. The only thing really different was how far spaced apart everybody was, and I think they actually enjoyed that part of it, and the fact that everybody had to wear a mask the entire time that you were in the courthouse. From Monday up until Friday morning, you had to wear your mask. Now, we were there on Friday, but on Friday, as we walked in and we were going through the metal detectors, we were told, because of the governor's new rule, that we didn't have to wear our masks inside the courthouse anymore until you went into the courtroom. Once you went into the courtroom, you had to put your mask on. But anyway, the whole process was really not as bad as I thought it was going to be, because I'm not a real big fan of wearing the mask all the time. I don't think anybody really is. And I thought it was going to be uncomfortable, stifling, but it wasn't. And Fortunately, we had a courtroom that was large enough to accommodate a jury veneer, which is the entire panel of potential jurors of about 35 people. Now, in a smaller courtroom where you couldn't space out 35 people, it would have been a lot more burdensome because you would have had to bring them in waves. And the process of jury selection, when you can do it with the entire panel at one time, well, I'll tell you, in this case, it took about 5 hours or so, maybe. No, that's not really even including the lunch hour. It takes a long time. And if we had to do it in waves, instead of having one panel of 35, if we had to have 3 panels because of a very small courtroom, it would have taken perhaps twice that long, if not 3 times that long. Probably about twice that long, because a lot of times you're asking the same question to the same people. But my report to you is that we're getting back to normal a little bit, at least in the courtroom. So I'm glad to report that I've been able to have a jury trial. Not many lawyers have, but I've had a jury trial, and for the jurors that may get called for jury service, it's not that bad. I got called to jury service before COVID, and I had to sit through the entire jury selection process. So I had to sit there like a sardine in a sardine can, with way too many people jammed up against you, sitting in these bleachers that are really uncomfortable. And that jury selection process took 4 or 5 hours, whatever it was. You start at about 10 in the morning, and the lawyers weren't selecting their jurors until probably 3 or 4 in the afternoon. And the whole time, you're stuck there, sitting there all wedged in between everybody, very uncomfortable. So silver lining with COVID is that now at least you're spaced apart. You don't have people right next to you as you're sitting there in the jury jury selection process. But one of the things that may happen during jury selection. Hey, good morning, Joe. Joe's back on Facebook. Awesome. Good to see you. Joe always comes up with very clever questions for me, and they make me laugh. So hopefully it says bring them on camera. Let me see. I'm going to experiment today. Today's an experimental day. Joe, I'm going to bring you on camera. Surprise, surprise, Joe. Oh, it says I can't bring Joe on camera. Sorry, buddy. I was going to surprise you with you're probably not showered like I am. But thanks for watching, Joe. Hope all is well up there in Orlando. Joe, one of my friends going all the way back to junior high school. So one of the things that can happen while you're picking a jury is lawyers have the opportunity to use what we call peremptory challenges. And again, it's not preemptory, it's peremptory. A lot of people mispronounce that word because they think you're preempting something, but you're not. It's a peremptory challenge. And at a minimum, the plaintiff gets 3. Each defendant gets 3. If there are 2 defendants, each having 3, then the plaintiff will have 6. It's meant to, even the playing field. But you're taught in law school, the basics are you can use peremptory challenges basically for any reason you want to get rid of a juror that you think is not going to be friendly to your case. Well, similar to state and federal law, where you cannot discriminate on certain bases, race, religion, that type of thing, you also cannot use a peremptory challenge on those same bases, race, religion, whatever it may be. Good morning, T. I see that Theron Lewis is watching from Louisiana. Nice to see you. Uncle T. If you try to exercise a peremptory challenge on a potential juror, and opposing counsel thinks to himself or herself, wait a minute, this doesn't smell right to me, that opposing attorney can say, Judge, I'm going to object. I want a race neutral. For example, I want a race neutral reason as to why the attorney is seeking to strike this particular juror. And you see that a lot when, for example, maybe the plaintiff is a African-American person. Oftentimes, and for example, my veneer panel up in Vero Beach 3 weeks ago, there were 35 people. There was not a single African-American person on my panel, not one. And so, not that this happens all the time, but if a defense attorney were to exercise a peremptory challenge on maybe the only African American person on the panel, when the plaintiff is an African American, the plaintiff's lawyer is going to say, I want a race neutral reason as to why you're trying to get rid of that person. And Florida law sets out an entire process that the court has to follow when ruling on a peremptory challenge as to whether it's race neutral or not. And so I just wanted to give everyone the benefit of a little bit of legal knowledge this morning. It says a party objecting to the other side's use of a peremptory challenge on racial grounds must A, make a timely objection on that basis, and the appellate courts are real sticklers for making sure that your objections are timely, appropriate, and really redundant. It's amazing how many times you have to object to the same thing for it to be preserved for the appellate courts to rule on. So it has to be timely. B, it has to show that the venire person, which is the potential juror that's seeking to be struck, is a member of a distinct racial group. And C, request that the court ask the striking party its reason for the strike. And that's when the court says, okay, defense lawyer, you're trying to get rid of an African American juror. What's your basis for doing that? So that's when the court asks. So the court must ask the proponent of the strike to explain the reason for the strike. At this point, the burden of production shifts to the proponent of the strike. So in this example that I'm giving you, this hypothetical, it would be the defense attorney who has to give a race-neutral explanation. It goes on to say, if the explanation is facially race-neutral, and the court believes that, given all the circumstances surrounding the strike, the explanation is not a pretext, the strike will be sustained. And so that's the important thing here, is that if as an attorney, if you're looking to strike a potential juror who is going to be protected because of a certain class, you better have a really good reason for doing it. It can't be pretext. It can't be nonsense. Because if it's nonsense, that's synonymous in this instance with pretext. And the court will, if the court feels as though your argument, your reason for trying to strike this person is nonsense, then the court is going to deny your ability to strike that person. So, now, in addition to peremptory strikes, which are the number is typically agreed upon prior to trial, and it's oftentimes not something that's in dispute, because trial lawyers typically have a pretty good understanding of how many peremptory strikes they're allowed to have. But another type of strike that you can try to exercise when you're picking a jury is a cause challenge. Now, cause challenges are unlimited, but they're also sometimes very difficult to get the court to approve them. But if you feel for one reason or another that you have a potential juror that is not fit for service, that is not going to be impartial, non-biased, is not going to be able to objectively listen to the evidence and listen throughout the case without favoring one side or the other, then you can exercise a cause challenge on that potential juror. And theoretically, if you had a panel of 30 people, and after asking all the questions and having all the discussions that we have during the process of jury selection, if you feel as though you have a cause challenge to all 30 people, you can bring 30 cause challenges. They're unlimited in number. And if you deplete the panel, well, one of two things happens. Either there's enough people that have been called to jury service so that you'll be given another panel of people and you start all over again, which means you're a day behind now, or a mistrial is declared because you don't have enough people that showed up for jury service, and then you get stuck back in line waiting for another trial date, which can take a very, very long time. So my mother is typing in a question, and I should have anticipated this because we talked about this just a few days ago, and I said to her, that is a really good question. I didn't research it, but for those of you that are listening via the radio, my mother asked me the question, can you use the Castle Doctrine to kill an endangered or a protected animal like an alligator or a tiger in your own yard? Now, when I answer this question, I'm only going to answer it in the state of Florida, because I'm only licensed in the state of Florida. I sound like a broken record, but I'm only licensed in the state of Florida. The Florida Bar wants everyone to know that I can only give advice that's good in the state of Florida. For example, Theron Lewis, who we affectionately refer to as Uncle T, a very, very close family friend of ours, lives in Louisiana. So if I were to give advice and Theron were listening to that and apply it in Louisiana, well, it may not be good advice in Louisiana. So just keep that in mind, T, if you're listening. But it would be good in Orlando, where my friend Joe is listening. But then again, it may not be good up in Buffalo, where my family often listens, my uncle, my aunt, and my cousins. So, great question, Mom. Thank you for reminding me. Unfortunately, as I got up early this morning, I totally forgot that I was going to be researching that topic, and I didn't. So my response, my knee-jerk response, without having done any research on this, is that if you can kill a human for the same reasons, then you can most certainly kill an animal. But my comment to my mother when we were kind of hashing this out a few days ago was that the way the statute is worded, it really only applies to another human, because it refers to, causing harm or killing another human, another person. The statute doesn't contemplate killing an animal. I would suspect that, and because of the way the statute is worded, now again, this is all just my own dicta, my own kind of from the gut response. Because of the way the statute is worded, if you kill an alligator in your own backyard and you're arrested, and your defense is going to be, hey, castle doctrine, because this thing was going after my kids, the state who's prosecuting you, the attorney would object to that, saying, well, the castle doctrine is not applicable because the way it's worded is only applicable to killing or harming another human. But there's probably something somewhere else, in animal statutes somewhere, that says that when required, you can certainly take the life of an endangered animal. Now, I don't think that there's a person on the planet that would disagree that if an alligator is going after one of your kids, you have the right to kill that alligator. I don't care what the law says. As a father, that's what I would do. But great question, and we'll see what kind of interesting answer we can get when I do the research. Okay, thanks, Mama. I appreciate that. And thanks for watching too, by the way, and thank you all for watching on Facebook Live. I've got a couple more topics, but I've been rambling on, and not my greatest show because of all the technical hiccups. But I did have a couple of other topics to talk about. Arbitration clauses for fun parks. Really, just be aware, if you are a proprietor that owns these fun parks or the bounce house things that people rent on the weekends and all this other stuff, if you want your releases and your arbitration provisions to be enforceable, make certain that the person that is signing them is the parent of, or is somebody that's at least an adult of the children that you're seeking to, that you don't want to eventually sue you. What happened was, in this case, out of Broward County, a woman brought a bunch of kids down to one of these fun parks, for her son's birthday party, and she brought several of her son's friends with her, but the parents of those other kids didn't go. She kind of rounded up a bunch of kids and drove down there, and when she got there, she signed them all in, and she said, yes, waiver, or yes, arbitration clause, I'm signing on behalf of all these kids, but only one of them is mine. And sure enough, one of the kids that was not hers got hurt. The case that I was referring to says he was hurt, catastrophically, which is unfortunate. I don't know what happened to the kid, but the court went on to explain in a very extensive legal discussion as to why that mother's signature for a child that was not hers was not binding on the child, and so the child was allowed to sue, and the arbitration provision that the facility was trying to enforce, for reasons that I understand as a trial lawyer, and if you're not sure why they would want to be enforcing an arbitration provision, then you should probably call me and we can talk about arbitration versus trial. But as a trial lawyer, I would vote for trial every time. I'm not a huge fan of arbitration, but the court said that the arbitration provision that was contained within all of the release documents that this other mother electronically signed were unenforceable. as to that child that was hurt at the fun park. So really just advice for those that are seeking to have those types of things enforced. Talk to your lawyers that are drafting those documents, and keep in mind that this happens all the time. I know for a fact that my son has been taken to one of these parks by another parent. Other parents are going to be signing in kids that don't belong to them. You need to understand that the liability waiver is potentially not enforceable based on the language that's in them. Now, the good news is, if you're listening and if you're interested, you can make them enforceable, but it depends on the language that you're using, and specifically the affirmations that would be obtained from the person that's signing off on these things. I went to a local wake park here. I won't give the exact name out.
1 minute.
But when I signed in, I had to do everything electronically on the tablet there at the registration, which is really cool. It's very up to date. But the kid that was checking me in couldn't have been more than 16 or 17 years old. And you can't expect that demographic to be as diligent as they should be when they're checking people in. So just be aware. Thank you so much for listening to me babble. Thank you for watching me on Facebook Live if you're watching. And again, my apologies for a bumpy road today. But I hope you all have a fantastic weekend. I want to thank you, Sharina, for another job well done. And everyone have a great weekend. If you want to call me, 833-VASTOLA. God bless. Bye-bye.